Applying for permanent residence on humanitarian and compassionate grounds is often seen as a last opportunity for people who have no other options under Canada's immigration system. These applications are decided entirely at the discretion of an immigration officer, based on the full set of circumstances the applicant presents. While every case is different, a significant number of refusals are linked to mistakes that could have been avoided with better preparation. In this video, we'll look at 3 common problems that can weaken an H&C application, and how each of them can be addressed. One of the most common issues is making vague statements without proof. For example, simply writing, "I have no support in my home country," or "My children are well settled here," does not help the officer understand the depth of the situation. An H&C application is not assessed on sympathy alone. Officers can only consider claims that are backed by relevant, credible evidence. If a statement isn't supported, it carries little to no weight in the decision-making process. Evidence can take many forms: school records showing a child's attendance, performance, and participation in activities, letters from teachers, neighbors, or community leaders describing the applicant's involvement and support network, medical reports explaining health conditions and ongoing treatment, government or legal records showing the absence of close family ties abroad. The more specific and relevant the documentation is to the claims being made, the stronger the argument becomes. It's not about submitting the largest number of documents possible. It's about selecting the right ones that support the key points of the application. Another frequent problem is focusing heavily on general country conditions without making a personal connection. It's common to see applications that include reports about economic challenges, safety issues, or limited healthcare in the applicant's home country, but without explaining how those conditions would have a unique or disproportionate impact on them specifically. In H&C decisions, officers must weigh hardship in the context of the applicant's own life. For example, if an applicant has a medical condition that cannot be treated adequately in their home country, that is a direct link between a general problem and their personal situation. Similarly, if an applicant's children are settled into a school system in Canada and would face serious educational disruption abroad, that is a specific hardship that goes beyond general conditions. The key is to move from "this is a problem in my country" to "here's why this problem will have a severe impact on me or my family." This personal connection makes the hardship argument far more persuasive. The third issue is leaving out important information. Sometimes applicants omit details because they think those facts are irrelevant or might be seen negatively. But gaps in the story can lead to unanswered questions, which in turn can damage credibility. An officer's role is to make a decision based on all relevant facts. If they notice missing information, they may assume the worst or conclude that the applicant is being selective about what they share. For example, if there was a past immigration refusal, it should be acknowledged with an explanation. Providing the full picture, even when some details may be less favorable, allows the applicant to control the narrative and address potential concerns directly. Consistency is also important. Information in the H&C application should align with what has been submitted in past immigration applications or with records held by government agencies. Contradictions can undermine trust in the entire submission. So, to strengthen an H&C application, avoid vague claims, link general conditions to your personal situation, and provide a complete, consistent account of your history. Presenting clear, relevant evidence and telling a full story gives the officer the best opportunity to understand why an exception to the usual immigration rules should be made.